Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my defensive co-host, Brett.
So defensive. So defensive. I am offensive, one might say.
Because finally, in the trial that nobody wants to watch, that we don't want to cover, we will reach the defense's case in this update. And boy, is there a lot to talk about.
There is. And I'll say this, I don't normally enjoy it, but I enjoyed it today. So,
I will say this much. This is a little bit of a spoiler. Don't worry what it'll be at the end of this episode. But I did turn it on, and I was, working. So I had other things to do during the day. And I turned it on. And I was like, wait, I thought it was the defense's case. This isn't helping the defense. This is a defense witness. Well, that's interesting.
yeah, I mean, we're definitely getting ahead of ourselves, but I was watching it today and I was thinking, well, they're going to do this experiment. And obviously it's not going to work because they're kind of juicing it, but let's see what happens. And they ran the experiment and I was like, what in the world?
So this is a prosecution witness.
Yeah. Like, is this, and we're still on direct anyway. So,
okay. But before we get there, to the defense's case, we do have to finish up the Commonwealth's case, right? And of course we are talking about the Karen Read retrial version 2.
Exactly. We're running it back. Okay. So we're talking about week 6 and 7. They have been science heavy. And we had Judson Welcher, who testified for the prosecution. And he essentially was your guy he did the accident reconstruction. Remember, he had Trooper Paul last time. Trooper Paul did a great job, but he just wasn't great on the stand. He got rattled. AJ kind of had his way with him. And so it's one of those things. If you can get through the theatrics to the data, Trooper Paul was great. If you can't, it's a problem. And so I think this time around, the Commonwealth, with this more sort of full-throated case, not really cutting any corners, they decided to hire a professional reconstructionist, and that's going to be Judson Welcher. And he was great, he's well qualified and everything else. And if Karen Read is testified, she may need to testify now. If Karen Read is convicted, it's probably going to be his testimony, though frankly, it might be ARCCA's testimony. We'll get to that later. And he will be
an MVP for each the defense,
exactly,
and the prosecution.
Exactly. So he is the only expert in the case who's actually going to examine Karen Read's SUV and John's vehicle. The tests he conducts are pretty thorough. He goes to the scene where John was found and presumably killed. He also purchased the exact vehicle Karen was driving to conduct testing. He used hundreds of photos. He made a 3D digital replica of the vehicle to aid in testing. And so he could do a lot of these sort of computer models to model various different things. There's different ways to do this. You can do a lot of this. Frankly, you probably can do all of it on a computer, and you can probably do it better on a computer, or you can do more practical testing. He does a little bit of both. He's got the practical side and the computer side. And the one thing he did first, remember, there's always been this question of when Karen Read's taillight, it's obviously broken, and it was broken in the morning. Whatever you think about this, her taillight was broken before Michael Proctor woke up that day, right? So maybe you think, yeah, it was broken, but they broke it more for the purpose of planning these taillight pieces. But it was definitely broken. And there's always been this question. If it wasn't broken from striking John, how was it broken? And the theory has been, if you watch the Ring camera, as Karen was leaving that morning, her vehicle sort of taps John's vehicle that was also parked in the driveway. It's very slow speed. It's very gentle. But this has been sort of the supposition that strike is what actually broke her taillight. It was very unfortunate for Karen if you think she's innocent, because how unlucky was she that just happened to be the day that John was murdered and she was being framed, and this just so happened to happen. Well, Welcher, he rules this out, that the SUV's taillight could break when Karen tapped the vehicle for a few reasons. Number one, it wasn't moving that quickly. The forces would have been very low. But the other fact is the taillight didn't actually touch the car. In fact, it was Karen's bumper and not her taillight, which would have touched the vehicle. And in fact, Karen had a slight scrape on her bumper, exactly where this contact would have been made.
When he said this, I was like, Of course, that's what the bumper's for, right? Like, I hadn't really
Yeah.
thought about that before, but then I was like, every car has a bumper, and then I, have definitely tapped like the edge of my garage, for example, and the bumper gets hit, and everything's fine. So Welcher then identified 2 trigger events in the Lexus records between when Karen's SUV left the waterfall and when it left the Albert property. Trigger 1 was a 3-point turn after Karen missed the turn onto Fairview Road. This is completely consistent with what Karen said about that drive. So we expected to see the 3-point turn. And why this is helpful is this is a point of reference that like you can trust Welcher, right? Welcher is identifying this 3-point turn that is confirmed by what Karen has said, which means you should be able to have confidence in this next trigger. So 8 minutes and 5 seconds after that 3-point turn, Karen's vehicle moves forward for a bit and then reverses, going 87 feet at 74.5% of the vehicle's throttle. Seconds after the vehicle begins reversing, John's phone registers its last movements until the next morning. 87 feet at basically 75% of full throttle. You have pressed onto your gas if you know how to drive. Not a small tap at all.
And a lot of you have been asking, how would you prove intent? Even though you don't really need intent. In second-degree murder, not first-degree murder. But the idea of this wasn't an accident. It wasn't just that she was drunk. It was an action she intended to do that led to his death, even if she didn't mean to kill him, right? How do we know it wasn't just her being drunk? This is a pretty good argument. It's such a good argument that Karen's blogger friend actually said on one of his lives, well, if she did that, it was completely intentional. It's silly to think it wasn't, which was a moment of clarity for him. And I appreciated that because that is the argument for second-degree murder. If she did this, this is intentional. She did not accidentally travel backwards. It's not like, oh man, I thought I was in drive. Like one time when I was 16, this is the kind of thing that happens when you're 16. I was in my parents' garage and I thought I had it in reverse to go back out, but I actually had it in drive and I ended up like ramming into the wall, right? Luckily didn't do any damage, but that happens. And particularly if you were drunk, you could imagine that happening. She thought she was going forward. She put it in reverse. Oh my goodness. Complete accident. You don't go 87 feet. It's 75% of the throttle and 24 miles an hour, by the way. And it's an accident. That didn't happen. So if you believe this data and you believe that Karen hit John, that's pretty much your argument for second-degree murder. And putting aside the fact that she then would have left him there in the snow all night long. I think this is the moment where if she is convicted of second-degree murder, this is the information that does it.
And I'll say, in the first trial, what really stood out to me was that 24-mile, the 75% throttle part. What really stuck out to me this time in terms of proving the whole, like, she's not just drunk, the 87 feet. I went outside and I was like, let me see what 87 feet is. That's a long way because I've definitely done that before where you think you're backing out, like in a parking spot, and you're actually in drive. How far do you go? A foot? At most, because you immediately realize what's happening and you slam on the brakes. This is gunning it for a distance. 87 feet does not get there by itself. That means your foot is leaden on that gas for that long. So to test the injuries, Welcher used himself as essentially a crash test dummy. Really committed here. I don't know that I'd use myself, but he wore similar clothing as John that night, got a similar cocktail glass, and applied paint to the vehicle so that during his test, he would be able to see how the vehicle impacted the body depending on its location. When Welcher tested the theory that the vehicle clipped John while he was holding a cocktail glass, the paint transfer was exactly where one would expect given John's injuries. Welcher used a real dummy to calculate the force of impact on John's head. A 40-inch drop would cause a level 3 skull fracture. John was over 6 feet tall.
And this goes along with the doctor from that Ivy League school, I don't remember, who testified. He was the brain surgeon who basically said the injury you're seeing is an injury from falling backwards and striking your head. And we talked about this some there's just so many people who are confused by this. I mean, you can tell just how much misinformation there is out there. This came up on the gallery. We're going to talk about some of the demonstrations that were done today, and they're just devastating. But somebody was like, I don't know. I mean, if I saw this, I would think that's a reasonable doubt for me. And it was like, what are you talking about? And they're like, I don't see how that caused the head injury. And it's like, no one who's actually making the real argument, there's plenty of straw man arguments out there, is saying that Karen Reed struck John in the back of the head with her SUV. No one is saying that. What happened is she hit him on the arm, spun him around, and he fell backwards, and his head slammed into the frozen ground from this height. And that was enough, as the doctor testified, to cause that fracture, to cause the laceration on the back of his head, which then sent energy through his brain to his eyes, causing the massive black eyes, the raccoon eyes that he had, and putting him in a position where he could not get out of the cold and eventually would die. That's the theory. And this description that Welsher gives is consistent with that theory. In addition, he also tested how long it would take to reach John's house. This is another one. The number of lies that just crumbled these last 2 weeks, one of them was, it is impossible for Karen Reed, from the moment of the strike, to get to John's house where her phone connected to the Wi-Fi. Because we know when it connected to the Wi-Fi, we know when this event occurred. So we know how much time was between it. Karen hit John, or supposedly hit John, between 12:32 and 9 seconds and 12:32 and 12 seconds. We have at this point, it's a very tight timeline. Her phone connected to John's Wi-Fi at 12:36:39, or about 4 minutes and 30 seconds later. So he tested all the various routes from the Albert house to John's house. And the story you've heard is that's impossible. No way, especially in a blizzard, she would have been having to go 80 miles an hour. You know, we talk about this sometimes in our cases where we lay it out, where it really is difficult to even imagine how people could make the trips they would need to make some of these murders work. But for her, easy peasy to make the drive between John's house in that time. Given the various possible routes she could have taken, she would have needed to average a speed of 37 to 39 miles per hour. And I'll just go ahead and tell you, if you have listened to the voicemails that Karen Reed was leaving at that time, she wasn't like taking a leisurely stroll.
She was
I mean, I'm surprised she didn't get there faster, to be honest.
She went backwards at 24 miles per hour and was only going 10. She only had to go 10 miles more going forward. She probably was going much faster than that at that point.
So, yeah. So, no problem. So, another myth sort of falls away. She absolutely could have made that drive. And Welsher sort of explains the difference between the Commonwealth theory, which we've talked about, which is a sideswipe, and the idea that John was struck directly by a vehicle, which didn't happen. And last trial, that was sort of ARCCA's whole basis, was there was no way he was struck directly by a vehicle. He wasn't. No one's arguing that. And he stated that John's injuries are consistent with a side swipe from the back right taillight. He says that striking John's arm would have broken the taillight if the vehicle was going over 8 miles per hour. And if it were going as fast as the TechStream data indicated it was going, about 24 miles an hour, it would have shattered that taillight. So at about 8 miles an hour, you start getting damage to the taillight. By 24 miles an hour, you're breaking it all to pieces. Welsher also presented an example of another pedestrian case, and they talked about this a lot, but he had one specific sort of example where there was a pedestrian strike by a vehicle, but there were no broken bones, there were no lower body injuries, just like John's case. And Welsher also noted that the height of the SUV's back spoiler is the same as the location of the right eye laceration on John. So essentially, Welsher is saying everything that had to have happened could have happened. Now, you had people, and when you're listening to these trials and you're listening to people talk about them, this is something to remember, because this is how people try and deceive you. So you have people say, well, he didn't say that's exactly what happened. He didn't get up there and say, I have proven definitively that Karen Reed did this with her SUV. So therefore, reasonable doubt didn't happen. That is not the point of this. The point of this is to show that all the various things that happened, that we know happened in this case, are absolutely possible given the theory the Commonwealth lays out. Once you know it's possible, once you know there's nothing impossible about the theory, then you take all that other evidence. You take the location of the taillight pieces, the parts embedded in John, the DNA, the hair. You take all that other circumstantial evidence and you say, this is all evidence Karen Read did it. And oh, by the way, it is entirely possible that her car did this. She is guilty. That's the way you have to think about these circumstantial cases. It's not that any one piece is, this is all we need. As we said before, you're building a wall. There are a lot of bricks. It takes a lot of bricks to get there. But once you build it, it's really hard to knock down.
Yep, exactly. Circumstantial case. That's what you do here. Now, of course, once you have a direct, you have a cross-examination, and boy, does the defense love to drag out these cross-examinations. So Alessi is on cross, so you know this is going to take some time. So they talk a little bit about Welcher and his company, Aperture's contract with the Commonwealth, because they want to point out that basically this is all paid for testimony, because the Commonwealth had a contract with them for $400,000 total. I'll just have to say, he bought a whole Lexus. You know, like that's not cheap.
Alice and I, we've hired experts before, and experts
is fine.
Are ridiculously expensive. It is a good business to go into.
We often say they get paid. This is not untrue. Even in the private sector, experts get paid more than attorneys per hour.
100%.
Absolutely. 100%. And this is why, actually, in a lot of those kind of pill mill cases that we do, a lot of our experts who were doctors, pretty soon, all they did was expert work rather than practice medicine, because they made so much more money testifying about being a doctor rather than actually being a doctor, which is kind of crazy, because being a doctor is like a very good profession in terms of your salary. So $400,000 for all that was done is not surprising with respect to an expert. This is actually why when you have expert. Okay, think about this. In other cases, maybe ones that have GoFundMes, what are they GoFunding me for? Experts, because experts are so expensive. You can't even retain an expert in most instances without a six-figure retainer. That's to put like $50,000 on the table before they'll even open their mouth and look at, have a conversation with you. They're like, give that money first, because that's only a fraction of what they're ultimately going to cost. A retainer is usually about 10%. So if you have a six-figure retainer, do the math. You're going to have a six-figure, five-figure retainer. You're going to have a six-figure contract. And that's what we have here. So while this was supposed to be a bombshell, just so you know, I don't think I've ever had a trial expert who was under $100,000. So under six figures at all. Now, there's also, Alessi goes on and says, well, Welcher, your slide presentation has changed over. Sorry,
keep going.
It's okay. Welcher goes on. Alessi goes on and says, Welcher, your slide presentation has changed over time. Again, what was Welcher doing? He was testing all the theories. And just like, what is it? When you have a hypothesis and then you do all the testing and then your hypothesis is either proven or not, of course it would change over time. And Welcher says that. He's like, that is completely common, because it changes as I do more tests. And I say, this is consistent. This is not consistent. And you go down certain paths. Your hypothesis is the question you're going to try to answer. It doesn't mean it's your conclusion. And oftentimes, if you're doing these sorts of recreations, if your topic sentence or your hypothesis is the conclusion, that's not necessarily what you're going to find every time.
And one of his changes was even based on something the judge had ruled on. So he had to change it because the judge had ruled on an evidentiary issue. Yeah, I mean, once again, Alice and I have had experts who did some pretty thorough stuff. And we talked about this before, the investigation never ends. The Commonwealth is still gathering evidence even now, right? I mean, and as that happens, you're feeding it back to your expert and they're refining what they did. And that's what you want. And you had some defense experts we're going to talk about later who learned things and were like, yeah, I didn't think about it. It's like, so not to get ahead of ourselves, but you have the dog bite person. Oh, it's a dog bite. Well, when you said that, you didn't realize there's no dog DNA. Well, no, I didn't know that. Well, did that change your view? No. It's like, is that what you want? Do you want the expert who's like, sorry, I've reached my conclusion. I will not change it, no matter what happens. No, you don't want that.
So when you do expert discovery, you guys all know what discovery is, right? It's where you turn over information to each other. Expert discovery is really interesting and tricky. You actually get to see drafts. Now, think about this. When Brett and I or any attorney writes a brief, if you're filing your first draft, it's probably going to be a really bad brief. So we write first drafts. Anyone who does any sort of writing in their profession knows this, and you iterate. Arguments change because you do more legal research or more facts come in. And so even it even makes sense within like the legal argument context that lawyers never file their first draft and their drafts change over time. Same as this expert, because they're probably talking with the attorneys and saying, wait, have you thought about this? Have you thought about this? Because the attorney's job is to make sure they have all the information. And so that on cross-examination, Welcher's expert testimony stands up. That's why there are iterations. So don't worry, there's still so much to the cross-examination. Alessi then talks at length about the absence of broken bones for John. We've already covered this, right? There are cases where, because of the sideswipe nature rather than a direct hit, you can have a situation where there are no broken bones. And in fact, we know that what ultimately killed him, was this massive head injury that was consistent with being sideswiped, spun around, hitting the floor from 6 feet up, because that's how tall John is. Now, after Alessi was finally done, there's a redirect, and the Commonwealth plays a clip. And after
we're going to play that for you.
Yeah, I was going to say, you may have just gotten a little taste of it, those of you who are watching this live. After this, the Commonwealth is done. So think about this clip, and then the prosecution rests.
And Alessi, bless him. He's been sort of up and down throughout this trial. There have been times where I thought it was good. He fell apart with Welcher. I mean, he really did. And he was getting so frustrated because Welcher he was in command. He was what you want from an expert. I mean, he just didn't back down. He could answer every question Alessi had. He obviously understood the science better. There was one point where Welcher's sort of talking with his hand, and Alessi has like this little temper tantrum meltdown where he asked the judge to stop doing that. Like he's doing something with his hands to insult me or something. It was so bizarre, right? And Welcher's like, okay. But this testimony went on for days, and it went on for a very long time. And the longer it went, it was one of those, we've talked about this before. The longer it went, the worse it got for the defense. And really, I think a more targeted cross would have been better. But as Alice said, this is the last witness, sort of, for the Commonwealth, because we have one more, the best witness, the ultimate witness, Karen Reed. So I'm going to play this for you, and hopefully you can hear it. And this is, of all the clips they played, this one is one that's it's just stunning that she did this, that her attorneys allowed her to do this. But that's what's happened in this case. So let me go ahead and start it.
I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car, and I hit him in the knee, and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
So there you have it. The last thing the jury hears from the prosecution is Karen Reed basically saying, if all those things they just proved happened, my lawyer, the one sitting over there, by the way, said I have culpability. So just once again, she started the case for the Commonwealth. She ended the case for the Commonwealth. I have a feeling we'll see more of her in closing arguments. But that's it for the Commonwealth.
So typically this is completely, in fact, you would probably be ineffective if you didn't do this. Whenever the prosecution rests, there's a standard motion for judgment of acquittal that the defense makes. Basically, that just says, Judge, Your Honor, you should go ahead and rule without the jury having to go deliberate that there hasn't been enough evidence for the prosecution to meet their burden. In this case, as in most trials, it is not granted. It is a horrible feeling when you are on the receiving end and it does get granted, but not in this case. So just so you know, if you saw something that was like, oh, bombshell, defense moves for acquittal because there's no evidence, you always make it. Now, as soon as that happens, the defense's case is now on. And the defense began with Matthew DeSagora. Disagra. Yeah, I put in an extra syllable. So the defense began with Matthew DeSagra, director of engineering at Delta Forensics. DeSagra's job was to undermine the timing argument of the Commonwealth. But honestly, the testimony itself was rather strange. Most of it was over mere seconds. It was kind of about whether John locked his phone just before Karen reversed or whether he locked it just after Karen reversed. The Commonwealth says, of course, it was just before, and then it never moves again. I can't say his name. DeSagra did no testing himself. He did not write a report. His entire timeline was based on Burgess's work. And there were times it seemed like he actually didn't fully understand what he was testifying about, which is not a good look for an expert on the stand. So remember what this is juxtaposed with. The witness right before him, Welcher, bought a vehicle, dressed up as John, was the crash test dummy. He's doing all these testing, and basically the first witness the defense puts up doesn't even really understand what he's testifying about or the report, and he didn't do any of the testing himself. Now, if DeSagra had done his own test, then he could have been a much more powerful witness, but since he didn't, and since much of what he said confirmed Burgess, he honestly just became kind of a nothing burger and a very strange start to the defense case because you want to start with fireworks.
Now, in defense of the defense, and I talked about this on Twitter. So a defense expert, the prosecution, they call an expert. They need to be doing the testing. They need to be doing exactly what you saw from Welcher. I mean, he's putting on the same clothes. He's getting in the same place. The Karen Reed people were like, it's just so, I can't believe they would use the same clothes. That's so disrespectful to John. It's like, I don't, y'all are whatever.
Really?
Yeah. And then they got slapped in the face today. Exactly. They got slapped in the face today when ARCCA did the exact same thing, because of course you want to use everything as close to the event as possible when you're doing scientific tests. But nevertheless, that's what you want from a prosecution witness. Defense witnesses typically don't do that. You see this a lot because, think about this for a second. Experts, we all know they're not unbiased, but they're supposed to be at least applying some level of scientific integrity to their experiments. Vigor, exactly. And if they don't, another expert can tear them apart. It could really be bad for their business, frankly. If you tell an expert, go do X, Y, and Z test, and they do it, and it's bad for you, that's the problem, right? Because you have reciprocal discovery obligations. You're having to turn that over to the other side. And if you're the defense, usually your client is guilty. So if they do a vigorous test, usually they're going to find out the science points to your client having done it. So it's not that unusual to see this. Very narrow scope, just sort of trying to poke holes, just like defense attorneys do, right? The expert is poking holes in the Commonwealth's case. So it may seem unusual that they're using all the Commonwealth's data, but they're doing it for a reason. And it actually does make sense. And you're going to see why. It is a bad idea to do a bunch of tests if you're the defense when we get to the end of this episode. So that's the first guy.
So perhaps this expert is actually a genius.
Yes, exactly.
He saw it and he was like, I see what's going to happen.
and you'll look, I mean, experts will tell you, defense experts, will say, look, if you ask me to do this and I do it, there's a chance
we have to live with it.
Yeah. And
this is honestly just like the cross-examination rule. Don't ask a question with an answer you don't know or don't want to know. Right.
Right. Exactly. And that's the same thing. Poke holes, don't test too thoroughly. So he actually was hire him if you're looking for a defense expert, because he did exactly what you want to do. He wasn't lying or anything on the stand. He's just, he's attacking the methodology of the Commonwealth, poking holes, that sort of thing. Still wasn't very effective, though. And it's the typical attack of prosecutors like us to say, you didn't do any testing, did you? You didn't do your own report, did you? You didn't look at this. You didn't look at that, right? Because that's what you're going to do. So then you had Jonathan Diamandis, and I felt sorry for this guy. He was a friend of Trooper Proctor. What do I tell you? He was a friend of Trooper Proctor and was in the infamous group chat where a lot of these texts went.
I do wonder how they came up with him, because there were other people they could have. I know. Like, poor guy. He just drew this like short end of the stick.
He was a nice looking guy. He's a nice guy. Maybe that he was the least offensive. I don't know.
Yeah, probably.
So poor guy. I frankly didn't think they should have been able to admit these through him because it's hearsay and he's not the one who wrote them and all this other stuff. But nevertheless, they did. So they introduced the text. Now, what's interesting about this? The defense gets up. They get him to authenticate them. They get him to introduce them, but they don't read them. And you got to think they had a plan when they were going to drop these on the jury, right? But instead, Brennan just gets up and he's like, okay, let's read them. And he just has this poor guy read these text messages, and he's having to read these messages that Proctor read for. And I'll just tell you, they're still bad, but there's something, it is nowhere near as effective to have some other guy sort of sheepishly reading these texts at the behest of the prosecutor. It was just a different effect. Now, there may have been jurors who heard it and thought, well, that's it for me. I mean, we can't get into their minds, right? But whereas last trial, this was the nadir of the Commonwealth's case. It was the worst part for them, and they had to recover from it. In this case, it just did not feel like it had the same sort of oomph and effect as it did in the first trial.
And I think why that is unlike when Proctor was reading his own text, you can't feel sorry for him. You think he's disgusting. When you are watching Diamandis read the text, you feel sorry for him. And it's almost like I couldn't hear the words because I just saw his face and how uncomfortable he was in having to read words that were not his own. And because it's a group text, that actually they probably picked him because he was the most unoffensive, right? On the text chain is my guess. And all you can hear is like, if a teacher calls on a student and makes them read whatever, like a sonnet or something, that's all it was. I was not really hearing the actual words because I was feeling sorry for the witness having to read them. And what Brett said earlier, I think, is a really good point. This is where the prosecution did a really good job playing the game of chess. So you have to authenticate and enter into evidence anything you plan to read later. That doesn't mean, and we do this with like business records all the time, where you might want to get in a bunch of pictures all at one time, but you don't necessarily show it all 500 crime scene pictures at one time, for example. So you may have like the photographer say, these are all, you properly authenticate them, you get all the pictures in, and then you use those pictures throughout trial because now they're already in evidence, and you don't have to stop each time you want to show a picture to lay foundation and admit it. But what the defense was doing here, they weren't, these were not crime scene photos or whatever. These texts, all they did was lay foundation, which is very boring. It's not substantive. All it says is basically, is there any reason for this person to know that these were the text messages? Did he receive them? Are these text messages what you remember them to be? In other words, we didn't make them up. That's what authenticating the text messages were. They probably were going to have another witness later on, counter or something, or maybe within his direct, going to pull out and tease out every single bad Proctor text. This was probably going to take like a week. And instead, Brennan blew up the bomb ahead of time so that it all blew up right in front of, the jury right there, as opposed to a slow leak, which was the right call, because this actually has nothing to do with the investigation. And then they can deal with it immediately and take that ball out of the court.
So then we had sort of a witness from Reddit, essentially, Kelly Deaver, a police officer, who was the most hostile witness you're likely to see. If we thought the random boyfriend and brother of one of the partygoers didn't want to be there, Deaver really didn't want to be there. The defense called her. She's hostile. That means you can lead on direct. That's what it means. So a year and a half after the event, Kelly, who had been on duty the day of the accident, well, the day that John's body was found and when the SUV was brought in. She would tell the FBI, because remember, there was this FBI investigation, that she remembered Brian Higgins and Sergeant Berkowitz, who I think became Chief Berkowitz. He might have been Chief Berkowitz at the time. I'm not sure. Entering the Sallyport garage and staying in it with the SUV for what she called a, quote, wildly long time. Now, you can imagine as part of the conspiracy, right? They were in there. Higgins was in there. Why is he even there? They're monkeying with the tail light. They're probably getting some more pieces off to go sprinkle them in the yard. You know, they're going to magically get them underneath the snow or whatever. So she tells them this story. The thing is, she then, after she tells this story, she checks because she wants to confirm that what she's remembering actually happened. And this was actually a really interesting look into memory and how weird it is. And she finds out that, in fact, she could not have witnessed what she remembered because she was already gone when this would have even happened. So she wasn't actually on duty when this would have occurred. At some point, the defense calls her and wants her to testify to what she told the FBI to essentially help out with this whole conspiracy. And she tells them, sorry, I realized my memory is wrong. I looked at the schedule. I wasn't actually there. I'm not sure why I remembered this, but it didn't happen. Right. They, according to her, according to what she testified to on the stand, then threatened, this is how she put it, threatened to have her charged with perjury if she did not, and this is the way she put it, not the way I'm putting it, if she did not lie on the stand for them. That's what she said. And she was so disturbed by this that she then called the FBI and reported the incident that the defense attorneys had, in her mind, tried to suborn perjury by threatening her with some sort of, and the perjury charge they were probably getting at was, if you lie to the FBI, that's a federal crime. It's 1001 violations, what we call it. So if she was lying to the FBI, that would be a felony offense she could be charged with. Now, she's saying, I wasn't lying. I just had a memory that didn't happen. I don't know exactly what she was thinking, how this happened, how this came about in her mind. As I said, it's sort of the kind of thing you see with people who are trying to remember things. And frankly, we talked about this some with the West Memphis 3 case. We talked about it with various other cases. Something really, really big happens in your life, in the area you're a part of, the police department you're in. There's a national inclination to want to be a part of it. And you hear, oh, did you hear what happened? You know, this police officer was killed and there's all this controversy. And you start thinking, and you're like, wait a minute, I was on duty that day. And I remember, Higgins was here. Anyways, I don't know how she created this memory in her mind, but she's adamant it didn't actually happen. So this became this very strange moment where she's not really advancing the conspiracy, which, remember, nobody even really knows about. Like, if you're on the jury and you were honest about how much you knew about this case, you're very confused about how all these people even fit into the conspiracy. Like, if she had testified in the first trial, after the defense had laid the whole conspiracy out, then maybe this is more effective. But you have this weird thing where she's talking about this false memory, and Alan Jackson is like as mad as he's ever going to be, and he's like blowing up on her, and she's like, my job depends on me not lying here. And I don't know, it was wild.
Okay, and here's the wild thing, because you guys are like, oh man, that's not good. The defense called her. They didn't have to call her. This is not a prosecution witness where they're trying to make the defense look bad. She didn't have to testify. But the defense, knowing this, knowing she'd reported the FBI, knowing that she refused to lie on the stand, still called her. I think this actually shows you how weak their case is. They had nobody else to call. Now, why they decided to call her, maybe they thought that their threats would actually take hold once she was sitting on the stand and she would, I don't know, lie, or that they would just, hammer her the fact that she had already made this statement before, try to get out the fact that she's now inconsistent. The fact that they did this to themselves is horrible, but I actually, just like that first witness who was an expert who didn't run any test, I think it's because they had no one better either. They had to get this testimony in, except, again, they're playing by the old playbook about the conspiracy when these guys are like, why would it matter if they're in the Sallyport for a while? What are we talking about? Who are these people you're talking about? They work there. That makes sense. So all of this is disordered, but also shooting themselves in the foot.
Let me just say, I just pulled an Alan Jackson because they called her Deaver. Her actual name is Dever. And this was like a moment where Jackson called her by the wrong name, and I don't know. It was just the whole thing it was wild. Go watch it. It's not even that long. Like if you're gonna watch anything, it only lasted for I don't know, maybe an hour. It was pretty short, but it was just wild. And she was, and depending on your position, either Jackson looked like a complete crazy person, or she seemed like she was the most hostile person to ever sit down in a witness stand. But it was as close to the drama you see in a movie as you're ever going to see in a real trial, because she's like, it was wild. You won't learn anything about the case, but if you want to be entertained, check out her testimony.
So, along the same lines of playing by the old playbook, the defense continues on this despite not talking about laying out the conspiracy. They yet again bring in who? A dog bite expert, Dr. Marie Russell. So, this is incredibly strange because in this trial, not the last trial, we're in trial number 2, the conspiracy never really came in. And so there is nothing about Chloe, the dog bite, anything. I think the jury right now is just like, are we at the same trial right now?
And what's weird about this lady testified last time and testified for like a hot minute. I mean, she was not on the stand very long at all in the last trial where it was all about the dog. You know, it was the dog every other word, right? And the whole conspiracy theory. This time, when the dog's barely been mentioned, she was on there for forever. She was on for hours and hours. It was just wild. I mean, no, the whole thing is wild. She was there over a break because she got to hang out with Karen and ride in a limo with Alessi. I mean, it's just, this was another, there were
We'll get there.
bizarre moments in this case.
So Russell essentially testified that she thought the marks on John's arms were from a dog. Okay, I know you're all already tired of watching this, but I recommend watching this testimony and the cross if you really care. To me, you'll only find this stuff kind of compelling if you already believe it and know about this whole Chloe conspiracy, which the jury doesn't know about. And this trial, even though it's being televised, is for the jury. So there were fireworks, though, when it turned out that Leslie had helped write her report, though she said it was largely just technical stuff like moving paragraphs. I'll say this much, kind of like how they made a big deal about Welcher's contract with the Commonwealth being $400,000. It is not uncommon for expert reports you work closely with the attorney. And I can imagine in this case, the attorney probably did more than just move paragraphs around.
Did you see the highlighting part?
Yeah. Yeah.
Where she like the studies she relied on were highlighted. And they were like, so who highlighted them? And she said Alessi. And then she was like, but he just did it because I didn't have my highlighter. And I was like, what? So were you like reading the study with Alessi sitting next to you? And he's like doing the highlighting for you?
Over
like,
her,
just,
like, I don't have my
have my
highlighter. Can you highlight for me?
The whole thing was strange.
It's all bizarre. Really? Yes, it is. It happens that the attorneys work with the experts as long as the expert can take it on as their own. But I think what you're seeing here is nobody as in the jury understands why this dog expert is talking. And then on top of that, this whole like Alessi is the one doing all the work behind it. Obviously, Alessi's not an expert. It makes her very ineffective, I think. So this is where it's bizarre. She doesn't testify for a hot minute. She testifies so long that they actually break for the day, and then she has to come back the next day. Now, typically, you can talk to your witnesses, you prep them, you know, that's totally common. We've talked about that a lot. But once they're sworn in and they're on the stand, you can no longer talk to them about the case. So that means during breaks, that means if you take a recess for the day and have to come back the next day, you're not supposed to, by the rules, talk to them because you can understand why. If you're already sworn in, you're already on the stand, you don't want to be able to be coached in real time as the questions are coming to change your testimony. You don't get to do that, right? The game is already set once you're sworn in. But apparently the next morning when they're coming in, while she's still a live sworn in witness, she and Alessi rode together in what she called a limo for the second day of her testimony, which honestly, that sounds like a violation of the rules. Sure, maybe they sat in the car and didn't talk at all. But I'll tell you this much. We basically
couldn't remember what they talked about. So
there you go.
You'll never know.
We don't even go to dinner with our witness who's live if there's a recess for the day. So they're going to come back the next day. Let's not even give the appearance
Say,
of
see you tomorrow. And
Exactly.
then that's it.
And we literally say that. We're like, sorry, go to Burger King by yourself. We can't eat together because just in case we accidentally talk about it because we're humans, right? So they probably violated the rule. But is this judge going to do anything about it? No. Okay. All to say is this testimony went on way too long.
A couple things about this. Number one, just a complete waste of time. This expert is the ultimate preaching to the choir. If you think Karen Reed's innocent, you probably got something out of this. If you don't think Karen Reed's innocent, you didn't get anything out of this. If you're on the fence, you didn't get anything out of this. This was like, frankly, if you're on the jury and you don't even really understand why you keep hearing about dogs, I mean, you could be thinking the same thing people have said, that like, well, maybe a dog came along later and like bit his arm, right? I mean, why is this even relevant? Like, why is this important? And it was so weird because she's talking about all these like punctures and all this other stuff, and there are no punctures. It's these like shallow abrasions. No, there's nothing that she's saying should be there. And of course, there's no dog DNA. And this was another like hilarious moment. I don't know if you guys have ever seen A Few Good Men, but Few Good Men has this amazing scene with, if you haven't seen it, go see it. Tom Cruise and blanking on her name, was married to
Demi Moore.
Bruce Willis. Demi Moore. So Demi Moore and Tom Cruise, great movie. But there's this one part where she objects and she's overruled. And she's like, I strenuously object. And the judge is like, yeah, you're overruled. And then Tom Cruise is like, oh, you strenuously object. Well, if you strenuously object, it must be something, right? And Alessi, he gets up and he's like, I strenuously call for a mistrial because Brennan had mentioned the DNA and there had not been anything about dog DNA in the case in chief. Now, obviously, the reason there had not been anything about dog DNA in the case in chief is because there's no reason for the prosecution in presenting their case to bring up dogs or dog DNA. But when you, defense, put an expert on the stand and have that expert say it was a dog, and you have evidence and you have a good faith basis for knowing that you have evidence that there's no dog DNA, you can ask the expert, are you aware there's no dog DNA? And you can back that up with testimony. And if you needed to, and this is just like one way you could absolutely do this, call a rebuttal witness. Hey, any dog DNA? No? Okay. Call Russell back. Hey, you remember when you said that about the dog? There's no dog DNA. Does that affect your thing? No. But nobody wants to do that, right? It's a huge waste of time. It's a waste of the court's time. It's a waste of the witness's time. So much better way to do it is when you have a good faith basis for presenting the evidence, you just go ahead and present it. And then if you need to call the expert later, you can, but you don't have to call Russell back to then confront her with it. This is not a big deal, obvious, plain, but he just lost his mind. And of course, the like little puppies on Twitter are like, oh, mistrial. This is such a big deal. Like, what an important moment in the case. This is so shattering. And it's like, yeah, they're not going to be a mistrial. And Judge Cannoni, which by the way, until this week, I did not know that was her name. I thought it was Cannon. Like I've been watching this trial for 2 years. It's Cannoni, and I didn't find that. I guess I've never listened.
Read well enough.
It looks like Cannon, but if you listen to the crier at the beginning, who's like, hear ye, all you have business before the honorable Judge Cannoni, and I was like, Cannoni? I didn't even know that. So anyway, she's like, it's so funny that to listen to her because Alessi's like losing his mind. And she's like, okay, Mr. Alessi, Commonwealth, what do you have to say? And they do their thing. She's like, okay, let's take 30 minutes. And so then they come back and she's like, overruled. You can continue with your questioning. Which
overruled.
She
just probably wanted a snack break.
Or I think she likes to smoke cigarettes a little bit. But
okay, fair
I don't know. It was just, I don't know, just the theatrics. And I'll just say, this is the side. I'm now totally on my soapbox. This is why cameras in the courtroom suck. I know all y'all want them. I know they're good for our business, but they lead to this. This would never have
only happened. Our business as podcasters, not as attorneys.
Right. Yeah. This never would have happened in a real court. You could have objected. You could have said, objection assumes facts, not in evidence. That's a perfectly legitimate objection. And then he would explain what I just explained to you about why it's, we should just go ahead and do it now. And the judge probably would overrule the objection. But the losing your mind, asking for mistrial, what it tells you, the defense is not very confident about their case, because you don't run around asking for mistrials, particularly on like just this random thing, if you think you're about to win. Yeah, like it was just like a red flag. If you're out there thinking you people are morons, she's going to win, free Karen Reed. Well, you need to talk to Alessi, because he apparently thought we need a Hail Mary and we need it right now. But it didn't work out for him.
Yeah. And that's a great point in real time of why I don't like cameras in the courtroom, because everyone's like, cameras, more transparency. They're going to showboat for the cameras instead of for the jury, do their job for the jury. And that's what we saw here. So next up is Dighton PD officer Sergeant Nicholas Barrows. So if you remember from the first trial, he actually testified in the first trial, but for the prosecution. But he was, remember, there were way too many witnesses. He was one of the frivolous witnesses that got cut around this time because the prosecution presented a much more streamlined case. So instead, the defense decides to turn him into a dramatic defense witness. So Barrows said that he saw the SUV at the Karen Reed residence before it was towed, and he said that the taillight was broken and a piece was missing. Now, it seems strange that he was saying this, but then the defense showed the SUV in the Sally port with all the snow melted and with a close-up of the taillight. Barrows said that this was not consistent with how he saw it, basically saying that someone had tampered with the taillight. But unfortunately for the defense, on cross, Barrows was shown the same photos and videos that the jury has already been shown and confirmed that, indeed, these images were consistent with the taillight as he saw it. So by the end, it was clear that the combination of caked on snow and the passage of time had skewed Barrows' memory. Do you remember, the hostile witness, how her memory also changed over time? We've always said this, direct evidence, not the best kind of evidence because we have faulty memories, especially when you're talking about snow being caked on and whatnot. So I think it was only bad for the defense because he says before the car was towed, the taillight was already broken. So the part of this conspiracy theory would be what Brett said earlier. The taillight's already broken. We have to break it up even more to like super prove the conspiracy. That makes no sense. So this type of witness shows you again how reaching the defense has had to be. But in the end, it was a devastating witness for the defense because they get the chance to show the pictures and videos they already showed in their case in chief during the Commonwealth's case. And he's like, you know what? I'm wrong. Now that you have all this in front of me, you're right. They're the exact same.
So after he testified, he had Lucky Loughran, the snowplow driver. Lucky didn't see John's body in the snow. Later, he saw what he thought was a Ford SUV parked in front of the Alberts' home. He also didn't see the basketball goal he hit that night. He claims he did see it, which makes you wonder why he hit it. Nor did he see the massive dumpster in the yard across the street. Brennan on cross brought out that the blogger threatened him to get him to testify, and Lucky's testimony has changed quite a bit over time. Brennan also displayed a photo of him with some FKR pink-clad warriors. And really, this was, once again, this is confirmation bias. If you think Karen Reed's innocent, then Lucky might have done something for you. If you think she's not, or if you're not sure, then he just didn't see John. I mean, I don't really know what else to say about that. Lucky's not lying. I don't think he saw John's body lying in the snow and is now saying he didn't see it. I just think he didn't see it because he was plowing the roads and it was snowing and he's colorblind and doesn't see that well. And he's just driving them down the roads.
And it was a blizzard.
And he never saw it. And then later on he said, I never saw it, but I don't really want to be involved in this. And then the blogger like threatens him and does all this stuff to him and he's terrified. So eventually does. Great. Turtle Boy was in the audience that day. And like the camera operator should be producing for sports, because after Brennan just rips Lucky apart in the nicest way, because that's the way Brennan does it, but really just points out, like, you were threatened by Turtle Boy. He did all this terrible. He said all these things about you. He was putting these pictures. You didn't like that, did you? No. And it didn't go away until you agreed to testify. I did it. And Lucky's like, no, yeah, it was, And then like when they take a break, the camera operator finds Turtle Boy, whose face is turning the same shade of pink as the shirt he's wearing, and like zooms in on him in this like low, slow zoom in. And it's like, it was lucky, could have been a great witness, but Turtle Boy had to put his foot in his mouth. And so it was a great moment. Like I said, that guy, get that man a producer spot in a sporting event, because he knew exactly where that camera needed to go when he had the opportunity to do it.
I think he was lucky. This is what he was living for all 7 weeks. He like had the picture and he was like, when this happens, my time to shine.
Yeah, my time will come. So after this, Karina Kolakithas, who you may recall is one of the Greeks, the Greek couple, she testified about how sweet it was when John kissed Karen on the forehead the night she killed him. She apparently had never seen a man kiss his girlfriend on the forehead before, and this really struck her. And that was about it. Now, here's another sort of a complete waste of time. She's supposedly, I say supposedly because once again, Turtle Boy had said she had some sort of bombshell she was going to drop. She did not. She didn't have any bombshells. She literally was just there to talk about how loving they were as a couple. And it's like,
which just makes you feel worse for John.
Right. And people were posting all these like loving photos of OJ and Nicole the day before he murdered her. And it's exact like you saw him, not her, him kiss her on the forehead. And so you think she couldn't have done this? Did you listen to the message she left right after his phone never moved again? Because there wasn't any kissing on the forehead in that message. But I don't know. The defense decided to call her. So she was up there for 5 minutes. It took no time at all. Brennan's cross was like 3 questions, and then he let her go.
So before you move on to how this week ended, I'll have to say the first like 5 weeks of this trial, geez, how is this hit and run trial lasting so many weeks? Was honestly pretty boring because it was just the facts and it was a hit and run and it was so obvious. Boring in a good way because the prosecution was like, it's a hit and run, it's a hit and run, it's a murder, done. But since the defense has been taking this on, it's been like a movie. And it's been, I mean, you can tell how animated we are. I mean, this is like, don't practice like this if you are in law school and trying to take tips on how to practice. The defense's case is flames right now. And it's all the things that are predictable, but it's also because of the positions they've taken. It's not like they've taken missteps. Everything they're doing is calculated and it's terrible.
And that brings us to today, which is basically the greatest day in any trial I've ever followed. It was so incredible. Just amazing. You should just stop listening to us now and just go watch.
Just go watch.
Just go watch Dr. Wolf's testimony. ARCCA, the infamous ARCCA. Dr. Wolf. I said, hey, by the way, Dr. Russell.
Sorry.
Go ahead.
Back to remember when we were like, the judge can't rule out ARCCA because of all the deleting of the text. And it's like, well, they're just going to let, ARCCA have to testify, even though they really should be struck. I am so glad ARCCA wasn't struck. So we got the gift of today.
So glad.
And if I were the defense, by the way, I would have moved vigorously for ARCCA to be struck. So I literally would have been like,
you're right, Honor, Commonwealth.
ARCCA was so dishonest.
We fall on our sword.
So sorry. You know what? Strike them. Take me away.
Strike them. Yes. Punish us, Judge. Punish us.
Do that. So I take it back. There was a misstep. I would have not objected at all when it looked like maybe ARCCA should be struck. I may have even been like, Judge, that was bad on me. It's not worth losing my bar license over. Strike them. I don't want someone in the pocket of the defense because I know that Karen Reed is innocent. I'm going to get an expert because any expert at all will come and see the truth. Get rid of ARCCA and then bury this. But instead, it all came to light.
Honestly. Okay. So as we talked about earlier, a little bit of, so if you have an expert, if you're the defense and you hire an expert and they do some stuff, they're consulting for you. You didn't really hire them yet. And they do some stuff and they come back and they say, oh, I'm sorry, we tested this. And frankly, your guy's probably guilty, right? You can say, you know what? Thank you. Thank you for your time. We're not going to call you, but really appreciate the hard work you did, right? And then you just kind of move on. But if you call them, then you have reciprocal discovery obligations to provide to the other side everything they did, including stuff you're not going to use because it wasn't good for you. That's the way it works, right? As we've said, we're not hiding the ball. Discovery, cross-examination, none of it should really be a surprise. So last time ARCCA, much like this first expert we talked about, really didn't do anything that could hurt the defense. They did almost no actual experiments. Now, they didn't look at the SUV. They didn't really do any experiments with the SUV. They built a cannon. They fired a glass into the back of the taillight to prove that, maybe that's what shattered it.
But a cannon.
Yeah, exactly. An actual cannon, a potato gun, essentially. Maybe as Karen was driving away, John was angry and he threw his glass and that shattered the taillight. And that explains it all, right? Because he did that and taillight pieces went everywhere. And then he went in, he was killed by the dog, right? That's essentially what they said. And they did some stuff on how, like, there's no evidence this is a vehicle strike, which always posited as a direct strike, right? And that's what they did. And it was what it was. It was effective for a lot of people. People who followed Karen really liked it. We were critical because we said, but they didn't actually do any real testing. They didn't really try and rule out anything the Commonwealth said. And I think I said in the last episode, if you want to really go after it, you have to prove that the Commonwealth's theory couldn't have happened. You can't do this straw man where it's like, well, they didn't strike him directly. You can't do that. Well, I was wrong. They never should have tried to prove that the Commonwealth's theory didn't work, but they did. So, and the first thing they proved definitively, to just echo what Welcher said, there's no way, and they testified to this in the first trial, there's no way that Karen Reed tapping John's car shattered that taillight. Just didn't happen. So they talked about their potato gun again. But then they decided they were going to do actual tests with a taillight and an impact. And what happens? And you're watching it, and it's like, at first it was the beginning of the testimony was strong the way it was strong last time, but then they start doing this, and I'm sitting there thinking, well, I mean, I guess they're going to do this, and the taillight's not going to crack, and there will be good arguments, and Brandon will handle it on cross, but there's going to be a moment here where the jury's going to see a taillight, and it's not going to crack. So then they start doing the test, and first it's like this disembodied taillight, and it's getting smacked by like something that weighed the same amount or whatever. And they do it like at 5 miles an hour, and it doesn't damage the taillight. But then, you remember what Welcher said? He was like, over about 8 miles an hour, it's going to start getting damaged. And then they do it at like 10 miles an hour, and all of a sudden, the taillight has a crack. And I'm like, huh. And then they go up, and they keep going up. And the higher they get, the more the taillight's cracked. And I'm like, what are you doing here? Like, you're proving that this could crack the taillight. And I was like, wow, this is really bad for the defense, but I had no idea how bad it was about to get because they didn't stop there. They then got an SUV and took it out to a parking lot, and they suspended this dummy from like a crane.
I'm sorry.
And they
literally suspended a dummy.
They suspended the dummy, and they put his arm out, holding a glass, right, to simulate John's arm. Now, this arm is like weighs 25% less. It's 25% less mass than John's arm, but nevertheless, they're using the arm, and they get this SUV, and they are going to reverse this car into the arm. And so it's like, okay, up until this point, like if the defense had just sat down, like they had put on no case, if they had just sat down, they could have said on closing, they could have said, do you really think anyone could reverse that fast? Do you think that's possible? Do you really think an arm could shatter a taillight? That's crazy.
And not get broken,
yeah. Do you really think that even if it did shatter it, that it would explode outward with pieces going everywhere like the Commonwealth tells you? That's crazy. That couldn't happen. So they get this car out there, and they reverse it at 28 miles an hour or whatever, 24 miles an hour. And it hits that arm, and the taillight explodes into and pieces are going everywhere. And the dummy like spins around just like the Commonwealth said. Its shoe comes off just like the Commonwealth said. And just like what happened to John, if it hadn't been suspended by like
it would have fallen over.
It would have flown off. Yeah. And the back of its head would have struck the ground. And it's like, what are you doing? And so just, for those of you.
Explodes, I literally was like, you see how hard it is to find all the pieces, guys?
Yeah.
Especially if it's snowing.
And so for those of you who are listening at home, you've got to go look this up. This is an advertisement for Patreon, because if you're watching right now, we're going to watch this together and we will
Get your
narrate
popcorn, guys, because
what
you can't
happens
make a
in
movie
this
this
video.
fun.
And I just want to point out once again, this is ARCCA who did this. ARCCA did this. And the only thing I can imagine is they got this video and they're like, well, we have to use ARCCA and we have to turn this over. And if we turn this over to Brennan, he's going to play this thing in the opening, the closing, and everywhere in between. So we're going to play it and just act like it helps us. They actually have the gall. They asked the wolf. And I'm like, doctor, your credibility matters more in this case. This happens. And they're like, so is that consistent with the Commonwealth theory? He's like, no, it's not consistent. I'm like, what are you talking about? It's not consistent. Like, did you just watch what we just watched?
Anyone with eyes.
So I'm gonna play it now, so you guys can see it if you missed this today. So here it goes. It's backing up. This is slow motion. Look at that! Look at that explosion. There go all the taillight pieces. The glass whacks the dummy in the face. It's just like
turning. He's turning.
It is exactly what the Commonwealth said happened. And the thing is, the best you can do with this is like, well, there's still like one piece of tail light left that was gone when it struck John. Well, two things. Or the diffuser still in there. That was another thing I talked about. Two things. Number one, the arm's not as heavy as John's arm. It's not attached to an actual body. But the other thing, there are a billion different variables for when this actually happened, right? And if they had done this 1,000 times, if they had bought 1,000 different SUVs and done it, they would have had 1,000 different brakes and all sorts of different configurations. And that's the way it would have happened. And then if this happens in the middle of a nor'easter with Lucky driving up and down the road in his Franken plow or whatever he called it, those little flimsy pieces of plastic are going to do exactly what they did. They're going to fly all over the yard. There was one that was a long way away. It was near the fire hydrant. The question that has been presented to us, and the thing that has been asserted from the very beginning of this, was that it is impossible. An arm can't break a tail light at 24 miles an hour. If it did, it wouldn't explode outward. The pieces wouldn't explode outward like you're claiming happened. Like, this disproved that definitively.
And remember what we said about Welcher? As good of an expert Welcher was, what we said was Welcher wasn't saying this is exactly what happened. You know who said that? ARCCA said it. ARCCA said this is exactly what happened. That's what's crazy. Welcher was the one who said these things are consistent with what we see. It could have happened based on the bumper of the scratch and X, Y, and Z. But Welcher's testimony was not this is what happened. ARCCA, the defense's expert, said it. And you don't want to know what I see? Like what I see right here? Honestly, this whole time, I was like, is an arm at the right angle to be able to hit the taillight?
Yep.
Right there. Right there. Like, if I were them, honestly, if I were doing the test, maybe have the arm be a little bit lower just so it wouldn't hit directly onto the taillight, right? Like,
watching it shatter like it does. And like the red pieces and the clear plat and everything else.
And then remember what we said about the woven fabric, how it was embedded. Now you see how that's possible, right? Not some like little needle from this conspiracy where they're like sewing in pieces of shards. Look at the explosion of the taillight. We see some big shards, but when you have shattering like that, if you've ever dropped a glass before, you know that you're probably picking up shards of glass for days because you can't find all the shards and they get embedded all over. They're in my sock. They're in the floor, in the cracks, everywhere. I mean, this is just wild.
Look, there was more. I mean, this all happened on direct. Okay. Like by the time direct was over, I was like, Brennan should just be like, don't worry about it. We're good. We're good. No questions. But he crossed the guy and was very effective and pointed out a bunch of other things. The part about the shoe flying off. Pointed out that the sweater that the dummy was wearing, I think the dummy was named like Randy or something, had the same holes in it as John's sweater had. Pointed out that Dr. Wolf had not passed this was a funny moment. This is sort of stupid, but there's a test you have to take to be like certified for whatever. He didn't pass it. And when Brennan asked why not, he said it was too elementary. It was like, he's too smart. to pass it. Is why he didn't
Goodness
pass it.
gracious.
So it was like, oh, okay. Well, you are full of yourself. And the sad thing is, he's still on the stand. So this, I mean, like, I would be like, Karen, I need some of that Grey Goose because it's gonna be a long weekend. I can't believe I got to go back and talk more about this. And the defense isn't done. I don't know what they're going to do next week, but they have another doctor they're going to put on who is going to say that despite what your lying eyes tell you that this isn't consistent, but this was awful for the defense.
And this
I mean, just terrible.
This really is crazy about ARCCA. They have a career after this, and to play this video and to say it's not consistent with the Commonwealth's theory. Are you kidding? Like, how much are they paying you? I'd like, like it is not worth it. Are you trying to get a 2-second role in whatever documentary is going to be made? Because it's outrageous to throw away your credibility of your entire career like this, especially when it's televised.
I know if you're just out there listening to this, you may feel like we're spending too much time on this. You have to go watch this video. I mean,
I've never seen something like this in any trial.
One of the criticisms of Welcher by the defense is that he had not done this. He had not actually tested in real life at 24 miles an hour. He'd done a very slow speed strike to show where the car would have impacted the arm, but he didn't do this. And he was like, well, I wasn't gonna let a SUV hit me at 24 miles an hour. And everybody kind of chuckled, but what a bad point by the defense. There was no actual video of an SUV striking an arm and shattering, the taillight shattering, until ARCCA. I mean, I cannot get over this. Like how I was blown away. I could not believe what I was seeing. I still can't believe what I saw when they did this demonstration.
I felt like I was in like the upside down world. Like, first of all, I couldn't understand why it was coming out in direct. Why? And then I think you're right. They just were like, well, we had to turn this over. It's going to be played. So kind of like what Brennan did to them with the Proctor text, like just try to take the wind out of the sails, except you didn't need wind. The sail was just flying high. Look at that. You can't watch it enough.
I mean, the fact that this dummy does this, like this dummy
and the
shatters that light like that. It's just, I mean, that's what happened. It just solves, it answers every question. You no longer have to take it on faith anymore. You've seen it.
Do you know what I may have done or what you should do on closing? They haven't done closing yet. So, I'm just saying, Brennan, if you're listening, they should play the defense's ARCCA, this overlaid with Karen Reed saying exactly what happened that they ended their case in chief with on top of each other.
100%.
And sit down. Don't even go through anything. I would end with these two videos because those are the defendant's words, her face on national television telling you exactly what happened, paired with the defense's own expert video. Done.
And the sweet irony of all the ARCCA's not a defense. It's not a defense expert. They were hired by the FBI. They're independent. And Brennan getting to be up there and say, and the last thing I want to show you is a video, not by a Commonwealth witness, not by somebody we hired, but by the defense witness, ARCCA. This is what happened that night. Play that. Boom. I mean, look.
You just sit down and
if there's an FKR on the jury, there's an FKR on the jury. And there's nothing you can do about it. This won this case today.
This would change my mind if I were an FKR.
It should. I don't know if it has.
It should change your mind because it's all defense. It is the defendant's words and the defense's own expert. This is just outrageous to me. I can't get over it.
I can't either. I mean, it's just I can't believe this. And when I watched it, because when I watched it, I sat there thinking, well, they're going to do this and it's not going to break the taillight. That's just what I thought was going to happen. And then they did it. And you see those pieces in the slow motion and the pieces are flying all over the place. And I'm like, what in the world? I can't get over this. I am stupefied by this.
No. If the defense didn't call ARCCA, the video wouldn't be admitted.
Right.
This is
don't even have the video.
This is what we said about what's her face, the hostile witness, right? The one where she's like, they tried to suborn perjury. That didn't have to come out. They called her. This video would not be here because it has nothing to do.
Yeah.
It's only because he was called as the witness.
If the defense doesn't turn this video over and Brennan says we got discovery violations, guess what the remedy is? They just don't get to testify. Like, if they weren't going to testify, you would not have had to turn this over.
I mean, this is just.
But they had to. And this is, I think this is another, the defense team has gotten so much out of the public attention on this case. They have benefited so much from it. But they created the crash daddies, the ARCCA experts. Oh, the independent ARCCA. ARCCA's so great. They got this video and they were like, oh my God, we have to play this. We can't not call these guys. We're totally screwed. I mean, it's just
and by the way, now looking hindsight at the past 7 weeks of trial, it makes sense. The crazy flapping. They knew this was a train wreck 7 weeks in the making that only they knew was happening, and they were in control of.
It's amazing.
If she's not convicted, I don't know. Let's just quit.
I'll say this
and just go be really full-time lawyers forever.
If she's acquitted, I'll die of a heart attack because I'll be stunned.
You won't be acquitted. You won't be acquitted. You're right.
If there's a hung jury, then I don't think you can ever get a conviction in Massachusetts. I think the case is too tainted because if this isn't enough, I have no idea what it is. How do you ever get an unbiased jury if they can't reach a verdict with this?
We said this at the beginning, or maybe it was during trial 1. This is not a close case. There are close cases that we have covered. This is not it. And certainly not with this defense video. Remember, we've always talked about, like, whoa, what's different this time? We said the prosecution's case was more streamlined. You know, the evidence is better presented, but there's been no smoking gun. Guess who brought the smoking gun? And the entire battalion, the defense. And we're
just playing the video over and over again. If you guys were watching, I mean, because it's like it's astonishing.
You know what? If this video was played first, we wouldn't even need the entire prosecution's case in chief. This is just insane.
And the other thing that came out today afterwards, Karen, helpfully. So Green, the expert, the one who came up with the 227 search, and that was Jim McCabe, the person who is the author of the conspiracy theory, whose faulty research ruined Jim McCabe's life and put her and her family and her friends through hell, isn't testifying this time. They're not even going to put him up. That has been so destroyed.
It's just like outrageous.
And if you or somebody out there is FKR, you are FKR because of that search. And the defense isn't even going to make the argument this time. Like, you need to wake up, people. I mean, if you're out there and you still think this woman is anything, fine. If you don't think the Commonwealth's proved their case, that's fine. I have no idea what you're thinking, but that's fine. Fine. If you still believe the conspiracy theory, go get help, because it has been as debunked as it could possibly be. There's more evidence that the earth is flat, that there was a conspiracy that Jen McCabe and her friends and their dog were involved in. The whole thing is absurd. I can show you a video of exactly what happened. I'm playing it now, and it was done by the defense's expert. So,
and good point. If you're watching this video, the lower body doesn't get hit by the car. This is the defense's own recreation.
It's just amazing.
The spinning around is just... And you know what's crazy about this? Again, we don't know exactly what happened, but this is a pretty good recreation. Look, and he's suspended because he's a dummy, and so he hasn't fallen over yet. But the force in which how close he would have had to bend for the car, he probably hit the side of the car a little bit. You know, like no heater was blasting, no music was happening. She knew exactly what she did. And you can see it based on this video.
It's just amazing. I don't know, guys. I mean, we often say there's no Perry Mason moments in trials.
That's a Perry Mason moment. But
if I had been on the jury, I would have been like...
I would have audibly gasped and had to have been like...
Why have we been here for 7 weeks? It's like...
The per diem's not worth it anymore, guys. Let's go home.
I mean, and Brennan's planning on calling rebuttal witnesses, including Welcher. I don't even know. I mean, I'm kind of like... I would just... I mean...
Whew. You know what I
Whatever, but
might do? Call a bunch of witnesses and just play this video for each of them and
over
ask
and over
one
again.
question. Is
Dr.
this what
Walter, did you
happened?
see
Yeah.
this video?
Is this what happened?
Let's watch it again. Let's watch it again. Do you see the pieces of red taillight flying off? Some of them are big, aren't they? Yeah. Some of them are small, aren't they? Yeah. Yeah.
Do you see how they
Some of them
splay
were
out? They're
impacting
not
his
all in
shirt,
one
aren't
place,
they?
huh?
Yeah. Oh, is that a
You
piece
see
of
how
that's
his
a piece
shoes
of taillight?
coming off?
See how they're going in all these different directions. You know, if it was really windy when this happened, what would happen to all these pieces? Oh, would they be blown over the yard? Oh, okay. That's a good point. I mean, and I would just use this video. I just play the video over and over again.
And over. Okay. I think we have said that piece, but man,
I don't know if we made the point, but you should watch the video because it's worth watching. I'm gonna play it again for the people who are watching it at home. Anyway.
Okay, well, shockingly, the trial is not yet over. They're coming back on Monday for yet more trial, but it's got to end this next week. So I think we will have jury deliberations next week. I would, if there is no FKR person on this jury, I would say we have a verdict quickly by the end of next week if it goes to the jury.
So, Canoni asked the jury today at the end to think about whether or not they could stay all day next Thursday.
Okay.
Which I guess typically they don't do that. So I think in her mind, and she had talked to the council about the scheduling. So I think she knows that by Thursday we're doing closing arguments. We're beginning the deliberations.
And I'll just tell you 3 more days of witnesses.
Well, and it may even be that they're going to be deliberating all day on Thursday. I don't know. You know, you just never know. But I will say this. If that's the schedule, there should be a verdict by the end of the week. If there's not, I will be worried.
Yes.
Based on everything we've seen.
We said this before. A quick jury deliberation usually means good news for the prosecution in terms of a conviction, because remember, acquittal, you have to get everyone to say there wasn't the burden of proof met. This should be fast, especially if the closing argument they just end with this video on loop with her saying overlaid. I mean, did I clip him in the knee, or the heater was blasting? Everything they played in that last clip before they rested their case in chief. It is just so spot on. And 7 weeks, 8 weeks of testimony, you can forget things. You cannot forget this. That's the crazy part too. This video isn't coming out in week 1. This is coming out right before they're going to jury deliberations.
Yeah. Like, I don't know what the defense got left.
Is it too late for a deal to be offered? You never are entitled to a deal. The prosecution at this point, I'm not offering a deal. Are you kidding me? You've put the Commonwealth through all of this for 2. You have dragged people through the mud. Like, it's principle now. They are not entitled to a deal, and I wouldn't offer a deal at this point. And you can offer, but if they wanted to, a deal can be offered at any point until there's a verdict.
For the good of the justice system and the people of Massachusetts, whether they know it or not, she needs to be convicted on every count and given the maximum sentence. That's what needs to happen, because
maybe this restitution for all of this,
yeah, I mean,
taxpayer waste.
Well, her and her parents and everybody else need to be sued into oblivion after this is over too, along with the blogger and maybe some other media personalities who sold this lie.
There are so 100% civil lawsuits that should be brought for, for libel, for defamation. Defamation suits almost never succeed. In this instance, where it's ruined lives and it's so obvious with her saying it's all her own words, I think they'll be very successful with defamation lawsuits.
It's amazing because you watch the video and the only part of the taillight that breaks is the part that's broken on Karen Reed's. They don't even get additional or different taillight breakage. It is literally the piece. That is
what's crazy.
Anyway, that's all I got.
Okay.
I think I made my point.
This has been awesome. I don't even think we need a question, but you guys, if you want a question answered, it doesn't have to be about Karen Reed. Please don't let it be about Karen Reed. It could be about anything, your favorite color, our favorite color, or something about the law, if that's what you want. If you leave a 5-star review, let us know what you think. I am really hoping our next update is the last update, and we're updating you that the jury came to the right conclusion, which is that Karen Reed is guilty on all counts. One can only hope. With that, Brett, is there anything else you'd like to add before we sign off for today?
Nope. That's all I've got. Good week.
That's all we got
Hoping for
except this
better.
video going on loop.
Yeah.
Well, guys, thank you so much for sticking with us. Karen Retrial 1. We didn't want to do it again, but alas, you guys are watching it. We're watching it with you in real time. Let's see if we can take it home next week. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Just think, if she hadn't been the hung jury last time, we wouldn't have gotten this video.
That is true. That's what I'm saying. All of this is just
We would have missed out.
absolutely outrageous.
They should, if they had just done the same
quick
testimony
question.
as last time.
Did they just like get lots of cars?
I think they replaced the taillight every time or something. I don't know. They said they didn't use the same taillight twice. So
Oh, okay.
they really
would've
thought they were going to do this
jerry-rigged
test.
I was gonna I would have done again. They're in charge of all of this, right? I would have been like, let's put in a stronger taillight, y'all.
Yeah. Wild.